Hello, everybody. Very warm welcome to this Access All Areas session. We are going to be having a panel discussion today with a number of legal regulators and also legal experts. And let's move on and sort of introduce the panel. Myself, Brian Rogers, I'm Regulatory Director at Access Legal, so I'm going to be chairing things today. We are hopefully going to be joined by Professor Stephen Mayson. He's just having a couple of technical issues at the moment, but hopefully he will be with us. He's an independent legal thought leader and certainly has had plenty to say in the past about regulation, hence the reason why I invited him as part of this panel. Moving on, we've then got Professor Chris Bones, who is chair of the of CILEX, so that's the Institute of Legal Executives, the Chartered Institute. And we've then got Iain Miller, who is partner at Kingsley Napley, who is a regulatory and public law specialist. And lastly, we've got Matthew Hill, who is Chief Executive of the Legal Services Board. So very warm welcome to you all. And thank you very much indeed for joining us. So moving straight on, because I'm very much aware that we want to provide all those attending with as much information as we can, I want to move straight on to the first question, and that's in relation to lawyer ethics. So the question is, a number of recent and ongoing inquiries, for example, the Royal Institute of Chartered Surveyors, the Post Office scandal, and the sackings of 800 people at P&O Ferries, those have raised serious questions over the ethical conduct of in-house and external lawyers. So the question is, do you think lawyers are too quick to prioritise the best interests of clients and commercial gain over the rule of law, the proper administration of justice, the public's trust, their own independence? And if so, what do you think should be done to correct matters? So, Iain, what's your thoughts on that one?
This is, and excuse me before I start, Brian, this is a topic that I get quite passionate about. There's 2 points I sort of want to make. First is legal ethics is getting a lot more complicated. I think what academically might be called the sort of standard conception of legal ethics, which perhaps a lot of lawyers grew up with, is as long as it's lawful, as long as it's in my client's best interests, and as long as I'm not doing anything that breaches my duties to the court, then I can basically crack on and do whatever I need to do for my client. There have been a number of things in the last sort of 4 or 5 years that have suggested, or at least indicated, that just is no longer a safe way of approaching matters. So to give examples, I mean, the obvious and big one is acting for Russians who are not the subject of sanctions. It's perfectly lawful, but clearly quite a lot of law firms very quickly decided that that was not something they wanted to do. The use of non-disclosure agreements, particularly in employment discrimination cases. Again, the drafting by solicitors for years of those types of agreements, which are still enforceable by the court, are now the subject of a warning notice from the SRA that says certain terms and conditions, which may in sense be still enforceable, would be improper and would be a breach of the SRA regulations. Slaps is another one. Strategic lawsuits against public participation, to give it its full title, is effectively the use of the litigation system to, on behalf of clients, to, it would be said, suppress adverse comments of those clients. But again, perfectly permissible within the litigation system, but nonetheless, the SRA is on the point of issuing a warning notice in relation to that. So, and then the one that's emerging, but probably isn't quite there yet, is environmental issues. So how far is it proper and appropriate for lawyers to act on behalf of clients who are contributing to climate change? All of those are all perfectly lawful, but the regulator and others say it is no longer ethical or proper for you to do that, which then leaves the old lawful, unlawful test, which is nice and simple for lawyers to understand because they should understand the law, a bit more difficult to navigate because we've reached a stage where there are much more complicated assessments of the interrelationship between the SRA principles and what you're being asked to do for your clients. So that's sort of part A. It's getting a bit more complicated. On the other side, we in this country have never properly trained lawyers in relation to ethics. It's been within sort of part of the LPC and SQE now to include an element of risk and compliance, but at a relatively basic level. And risk and compliance obviously is important, but is effectively the outcome of ethics. We've never taught people why do these rules exist. Therefore, give them the toolkit to decide how they're going to balance their competing duties to their clients, to the administration of justice, and indeed to society as a whole, and the role of lawyers in society. That issue has just never come to the attention of those who are seeking to qualify into certainly the solicitor's profession. In fairness, the BSB do have a separate ethics paper in their qualification. So we are, and have been for many years, putting a series of, or pulling people or admitting people into the profession who are not well equipped to deal with the increasingly complex professional ethics environment in which they're working, which is a problem. And I'm delighted that Matthew and the LSB have certainly started to do work in relation to this area, and what are we going to do about it? Because I think it can only get worse, it can only get more complicated, and we need to find a way in which we can upskill, backfill, whatever you like to call it, the profession in relation to ethical issues, and whether that is by, at the educational level, increasing the amount of ethical training and making it compulsory as it is in the US. You can't take a US bar exam without having done an ethics element of that, and every US law school has an ethics professor. And do we need to do some form of continuing professional qualification or education in order to make sure that that those that haven't had the benefit of that ethical training are much more able to cope with the society they're advising and what their duties are. So yeah. I suspect training and education would be my solution. And then hopefully the sort of the RICS post office and other cases might be less likely to occur. But we might end up with sort of better lawyers who understand their duties better.
Indeed. Thank you, Iain. I can see that Stephen has joined us. Stephen, can you hear me? You're on mute, Stephen.
Yes, I can.
Brilliant. There we are. Really good to have you on board, and hopefully the technical issues will go into the background and we'll keep you with us. So, Stephen, if you could give us your thoughts, as I was saying, you may not have caught the question, but in effect, it's, do we think that lawyers are too quick to prioritise their own interests and the interests of their clients rather than looking at the rule of law and other things like that? And what what are your thoughts on what we should perhaps be looking to do about it? So what do you think?
Okay, thanks. Sorry, I was late. Sorry, I missed your pearls of wisdom. So I hope I don't repeat or disagree. I think my first comment is that this is not a universal issue. Not all lawyers are unethical and doing the wrong thing. So we need to be careful not to demonise the whole legal sector with ethically dubious thoughts or practices. But I do think there is evidence of sufficient imbalance in the way in which too many lawyers perhaps look at their professional interests in the round. And I think it is clear that some lawyers, both in external law firms and in in-house legal departments, do indeed identify too closely with their clients. And that skews their approach to how they advise And indeed, in some cases, I think they forget to ask the basic question, who is my client? Who is it to whom I owe that primary duty to act in the best interests of? So I think it's that question, do I identify too closely with a client or with my organisation is a very live one. The other problem I see all too often in private practice is the perverse incentives of targets for organisation.
Well, it looks
Again,
like
skew.
I think we've got problems, Stephen, with your verbal.
The truth.
Yeah, Stephen, it's very difficult to understand what you're saying, I'm afraid.
Yes. Okay.
Yeah. What I'll do, Stephen, I think, is I'll move over to.
Maybe I should just disappear in that case.
Yeah, I think what I'll do, Stephen, is I'll move over to Chris for his thoughts. If Ryan and yourself can see if we can sort out the voice issues, then obviously, be pleased to have you back. But Chris, over to yourself. What are your thoughts on this one?
So I quite like to build on both Stephen and Iain, actually. So I'm no way the expert practitioner or the leading thinker. In fact, I'm not a lawyer, so I'm going to come at it from a very different stance, which is from my experience of both in business and now in legal services. But like Stephen, whilst there are sort of a historical and literary trope about lawyers, as in any profession, the vast majority of legal professionals that I've met or experienced are honest, decent people, intent on meeting all their obligations, personal, professional, legal. And I think let's start there. And that's because I'm not sure we have a crisis of ethics any more than in any other aspect of civil life. But there is a pattern that I've watched in business and politics and in society in general, here in the UK and more widely, where I think the mores of life, if you like, are no longer strongly underpinned by an inheritance and the importance of truth and the need to act with integrity. And indeed, ironically, I wrote a prize-winning book about the problem in business in about 2012. And I have to say, regrettably, I'm not sure much has moved on or been done despite it. But you don't have to look too far at the political soap opera we've lived through this year or in previous years, or indeed what's happening at the moment in the midterm elections in the United States, to see just how far this sort of concept of alternative truth and the peddling of stuff that is patently untrue is not only happening in parts of society, but is lapped up by people willing and wanting to buy in to a different reality, to perhaps the one the rest of us see. And the problem in here is the way that the law and society then interact as we work our way through this, whether it's in politics or in business or in personal life. And clearly, but for the law, the erosion of these sorts of basics of truth and integrity are toxic for justice and for the wider conducting of business and private lives. So, I want to start there because I think if we picked on the law in the vacuum, I think we'd miss that an awful lot of pressure on the law and law firms and legal professionals comes from other parts of society and the way they want to behave and the way they want to be, if you like, the client side of it. Now, there is a significant difference, clearly, between ethics and personal morality, but they have a connecting nexus, which is the importance of values. So I'm going to do my business school professor bit for a minute and just make a point here about values. A value is a belief we hold so dearly that it determines the decisions and behavior we have in our day-to-day lives. And so values are a really quite important thing. And it's quite clear when you deal with a lawyer with good values, or any individual with good values, they come through in the way they think, the things they decide, the advice they give, and so on and so forth. And so what I think we're talking about when we talk about ethics in the legal sector is really about behaviour. And it's the way people behave in respect of their firms, their clients, and the representatives of other interests and other clients. And what do we do to counter some of the corrosive trends that are prevalent in our wider society, such they don't undermine confidence in our legal system as a whole? So let me take Ian's point about professional education. So the good news is when we launched the CILEX professional qualification last year to create a fully authorised CILEX lawyer in one go, if you like, the new CPQ, a key and obligatory part of that qualification is to maintain high standards of professional and personal conduct, justifying public trust in you, your profession, and the provision of legal services. And there is a compulsory module now, as there is in the US Bar, for an ethics module to be passed. So the competence acts with integrity, impartiality, independence, demonstrates principled behaviour, follows rules, adheres to organisational and professional standards, and manages risk, constantly demonstrates highest levels of sound judgment, professionalism, and integrity, refusing to compromise on standards in the face of client, supplier, or internal pressures. Now, that is not just the standard. The delivery of the education creates case studies, aids to learners, gives people the opportunity to exercise their judgment in their learning, test it out, be challenged in the way that they think, and the sort of decisions they're going to have to make. And it's really important that in that we bring in components around judgment, managing conflicts of interest, whistleblowing, anti-money laundering, bribery, use of social media, prejudice, and poor practice. So I think, at least some of us are responding in an educational sense, and I think that's a good thing and an important thing. But, and there is a but, behaviour in law firms and in-house teams is a leadership issue. Leaders set the culture for their firms. And, we're a body that represents not just qualified lawyers, specialist lawyers, but a very large number of paralegals. And the people we represent tend to be a bit further down the food chain in a law firm or an in-house legal team than the Law Society or the Bar Council. And the issue quite often for our members is the instructions they get, the behaviour from the top, and the way they think they're encouraged or intimidated or persuaded to behave in a particular way. And those are leadership challenges. And you only have to look at the experience of being employed in a law firm. Look at the stuff from Law Care, look at the latest, the CILEX data from our member survey last year, to realise right across our sector, in in-house teams and in law firms, the employment experience is not a particularly pleasant one, regardless of how you've qualified. There is a great deal of pressure. There is a sense of, quite often, some intimidation to behave in a particular way. There's a great deal of requirement people feel to have to conform to an internal norm rather than necessarily stand up for their own values. I think culture's been ignored by a lot of law firms. I think quite often law firm partnership teams are quite ill-equipped. They're pretty undertrained in management. Many of them haven't gone through management training of any sort or any formality. They're great lawyers. They're not necessarily there to be great leaders. And now they're going to have to be great leaders. Because the only way you fix the sort of moral compass of your law firm is to make sure the moral compass of your leadership is pretty much pointing in the direction that the professional bodies, the regulators, and clients expected to be pointing in. And there are some really interesting challenges internally in that leadership ethic. So, for example, if you took our members, how ethical is it that you pay qualified solicitors more than you pay equally qualified CILEX lawyers for doing the same job? How ethical is it that you don't pay CILEX lawyers training and membership fees when you pay solicitors? And how ethical is it, particularly when 75% of CILEX lawyers are women and nearly 20% come from Black and ethnic minority backgrounds? I'm not going to answer the question. I'll leave it there. But it's a sign of the internal cultural issues that then bounce out into the way law firms choose to serve their clients and choose to tackle their role as litigators. So standards for professionals is right. Regulatory response and challenge would help. But actually, I think if we're really going to tackle this issue, the leaders of law firms, the senior partners and the partnership groups and the managing teams have to face in to some of their cultural problems and the experience of their employees and the sorts of decisions and behaviors they have in their internal firms, because they, in many ways, represent the sort of behaviors they then take out. There are some great exemplars of people who do it well, but there are others, I'm afraid, who really need to take a good look.
Thank you, Chris. Totally agree with what you've said there. So really interesting stuff. So let's hear from Matthew at the Legal Services Board. Over to you, Matthew.
Thanks, Brian. Excuse me. Now, one of the disadvantages of going last on a panel session like this is you sort of are faced with people playing battleships with your speaking notes. So I'm going to try and salvage what's left and perhaps develop a few thoughts on the back of what's been said. So one of the questions that we've started to ask at the Legal Services Board, against the backdrop of the regulatory objectives that we are under a statutory duty to pursue, including supporting the constitutional principle of the rule of law and adherence to the professional principles, is how well connected is the legal profession to a more sort of fundamental purpose that has to do with the rule of law and the selfless ethics that are needed to underpin it. So in the UK, as in many democratic jurisdictions across the world, society invites lawyers to become part of a group in which the public places its trust. And we hand to legal professionals stewardship of the codes, rules, and conventions that, with no sense of hyperbole, safeguard our civic and civil way of life. I mean, the law and lawyers is what stops us, taking shotguns to each other over a, dispute over a boundary fence. Not always successful, but most of the time it is. So when you look at some of the issues and problems that emerged in recent times, we've listed a few today: P&O, the Post Office, SLAPs, NDAs to cover up sexual misconduct, perceptions of Londongrad, weaknesses in anti-money laundering controls, for example. It's easy to form a view that perhaps that fundamental connection isn't as strong as we might like. It sort of leads us to today's question: what do you do about it? And at the same time, we are hearing more and more from lawyers who are finding themselves having to negotiate what I think are at heart often very difficult conflicts of interest between the client, who may also be one's employer, let's not forget, and the broader public interest in the context of the law. Now, I think, and this is one of the reasons why the LSB is getting interested in this area, I think we owe it to legal professionals to provide an essentially supportive regulatory framework that equips them with the tools and the abilities to manage those conflicts of interest, whether they work for the CEO of a FTSE 100, a local law centre, a city chambers, or, dare I say it, as a public servant, the Secretary of State. At the heart of many of the issues we've seen are a sort of inability to see and manage those conflicts effectively, and to know what to do when those conflicts become unmanageable. And I think it sort of behoves us all, whether we're regulators or leaders in the sector or whatever we happen to be, to help provide that framework. And I think in doing that, we also, and I should caveat here, I work for the LSB, we're not the arbiter of the rule of law or the determinant of what constitutes ethics in the law. We have a strong interest in setting an appropriate regulatory framework, but I'm going to venture a little bit more broadly anyway. So in arriving at this framework, this effectively an ethical decision-making framework, we need to ask ourselves questions like, what is the law for? Is it for securing justice? Is it for illuminating principles? Is it for establishing fact? Is it for building consensus and resolving disputes in a way that people can live with? Or is it for obstructing, intimidating, destroying one's opponent? I think they're really fundamental questions that, all legal professionals ought to be able to ask themselves. How am I deploying this incredibly powerful tool with whose operation I've been entrusted? I think that's a really interesting set of questions. Picking up on things in particular Iain started off with, I think we need to sort of distinguish between lawfulness and ethical practice and moral issues, let's say. Lawfulness is not the same, or being lawful is not the same as being ethical. And being ethical is not the same as being moral. Now, from my point of view, as a regulator, I've long held that regulation has nothing to do with morals. It's got a lot to do with ethics. And, we've got to make sure that we know what we're talking about. It sort of brings me on to a point that Stephen, God rest his soul, no longer with us, said, which is he said that not all lawyers are unethical. And at a headline, I sort of agree with that, but I do wonder whether it is in fact helpful to see being ethical as a property of the individual, as opposed to a property of decisions that are facilitated by that individual or the actions that that individual takes. And I can see circumstances in which bad people make ethical decisions and good people make unethical decisions. And I think it might take the heat out of the debate a little bit. The ethics as a function of or an outcome, if you like, rather than a property of the individual lawyer. I'll just round off by saying a little bit about where, excuse me, some of the solutions might lie to this. Now, we've talked about education and training. I think that's absolutely key. One of the questions that I find myself asking in my job is, who is having the conversation with the individual lawyer when he or she is joining the profession that says, you do realize, don't you, you're taking on something that is more than just a job. We are giving you something that has a sort of pervasive, transcendental value in society. And how you treat that thing, the law, will make a difference across society. And it doesn't matter whether you're conducting the most mundane conveyancing transaction or you're the president of the Supreme Court. How you treat that thing in your hands, the law, makes a difference. And being admitted to this group of people comes with privileges, yes, and make the most of them. Privileges in terms of following your calling, and for many, a living. But it also comes with obligations. And actually, regulation is at the heart of securing the obligations from that contract between society and the legal profession. The very last thing I'll say is I couldn't agree with you more, Chris, about the role of leadership in relation to these issues. Much like another, topic of prominence at the moment in law, diversity and inclusion. I would see the solutions here as being sort of 80 to 90% leadership, backed up by 10 to 20% regulation. Regulation can identify the things that mustn't happen and stop them happening. Leadership can identify the things that have to happen and make them happen. And it's that coming together of leadership and regulation, and in fact other factors that will move us closer towards the goal. I'll pause there.
Thanks, Matthew. All good things to obviously think about. I mean, I've got a couple of observations I'd like to make before we move on to the next question. One is a little bit personal because it's my daughter and she's studying law at the moment, so she's a second year law degree student. And I asked her about, well, what training are you getting? And basically, she's not getting anything in effect. Well, how does that start a lawyer's career off well if they haven't been told, well, what are the ethical expectations? So I think, in terms of the law colleges and things like that and the universities, I think there's definitely something that needs to be picked up there. I think the other thing is that I'm following very, very closely the post office scandal and the public inquiry and things like that. And one of the things, and okay, I've picked it up in this particular inquiry, but it applies really across the piece. But, when you've got people who are later found to be innocent, but their lawyers being forced into a corner to basically get them to plead guilty to a lower sort of offence to stay out of prison, it just doesn't, it seems to me that the system needs to be fixed as well as the sort of the personal ethics of lawyers. But I think, that is one that really raises sort of eyebrows, that we clearly have people who are innocent. They were forced into corners, as I say, to plead guilty when they really didn't need to, but it was the best of a bad option. So it will be interesting because, at the moment they're sort of talking to some of the technical people in the inquiry, but the lawyers have certainly come under fire in there, and it's really going to be interesting to see what the media says about this. And I think, that is one of the concerns that I have, and I agree with all of you that the vast majority of lawyers are good, hard-working people. There are few who are doing the wrong things. The problem is, as we've seen with the media playing on the sort of the fat cat lawyers agenda, that if that sort of agenda isn't challenged, then the media itself will then say that, to the public, of those who are listening, all lawyers are unethical. And I think that's where perhaps the Law Society and other membership bodies need to get out there and basically say, yes, there are issues, but as one of you said earlier on, there are bad apples in every barrel, but we shouldn't allow the media to then lead that agenda and basically paint everybody as being unethical. So that's my two penneth on that one. I don't know whether anybody had any comeback on that or anything that anybody else.
I do, Brian, if that's all right. And I've made it my life's mission to challenge the bad apples analogy wherever I hear it, because I'm a regulator by profession, I guess. It's not what I wanted to be when I was, a little boy. My parents' eyes, but something happened to me that made me a regulator. But the flip side, the plus side of that is I've had the good fortune to have worked in regulation across quite a wide range of sectors now. And the bad apples trope, if you like, is one that you will hear everywhere. And I think it does professions and businesses a bit of a disservice, because it implies that the only thing that needs to be improved in a particular area is people who are sort of willfully bad. They're setting out to be bad. They're setting out to subvert and not be compliant. And I think that's a mistake, because while from the experience I've had, it is undoubtedly a very small minority that set out to be bad. There's a whole sort of tier of people who can be helped to be better by explaining things better, by giving them support, by holding up a different mirror to the way that they're behaving. These are people who want to be the best, insert profession here in the blank box. They want to be the best that they can. But for some reason, a combination of reasons, they haven't been equipped with the tools to be the best that they can. They haven't been helped to make the best decisions that they can. And regulation and leadership can help those people, but the more you focus on the bad apples, the less you can help those people who would benefit from it in that very supportive way. So I don't mean to sort of aggressively interdict your metaphor, Brian, but I think it is quite an important point.
Yeah, no, I think it's well made. Yeah, Iain.
Oh, sorry, Brian. I was just going to echo what Matthew said in that before I started sort of advising law firms and law firm partners and things, I prosecuted for the SRA in the SDT, and I've lost count, but several hundred cases I was involved in, and I after several years came to the conclusion that the number of genuinely evil, bad, however you want to describe it, people I came across was quite limited. Maybe one or two. Most of them were just the victim of circumstance. They did something stupid and then they tried to cover it up. And then they made it worse, and it spiraled out of control, or they were a sole practitioner who was up against the overdraft facility and so borrowed £500 from client account 1 month and then needed 1,000 the next, and suddenly 6 months later they were in a hole. And yes, they weren't bad people. They were dishonest people, which is the sort of, obviously they weren't very happy about being found to be, but they were just, life got the wrong end of what they wanted to do, and that's what happened.
Yeah.
And I suspect that when life gripped them in that unhelpful way, they weren't equipped with the methods of thinking to help them save themselves from the outset.
I think this is right. This is where culture, I think, comes in. If you join an organisation that asks itself the right questions, you're far less likely to go out of the crowd because you know the questions you have to ask, and that sort of sits itself through the organisational DNA. In the businesses I've worked in, I've always called it the mum test, which is if what I've decided is going to turn up in the front of the Daily Mail on Monday, would my mother be happy to see my name associated with whatever I'd done? And it's not a bad place to start, actually, because most of us don't want to embarrass ourselves in front of our parents more than anybody else. And actually, when you start talking to young people about that type of a decision, because they come from a world that is absolutely, in terms of moral philosophy and moral judgment, education free now, in terms of school and university, we're probably the first people as they go into their first job that they meet who's putting a mirror up in front of them and saying, hang on a moment, take a look in this. And the issue for me is most law firms don't see themselves first and foremost as employers of people. They see themselves as deliverers of legal services to clients. And every 6 minutes the till goes up, click, here we go. And that's the induction that young people get coming into the law. I too have a daughter in the law and a son-in-law. Both of them are attorneys at law of the Bar of the State of New York. They both work in the UK. And what's really interesting about their attitude to the law has been the way that in their education they got confronted with these moral questions, these ethical questions, in a way that many UK lawyers, whether they're in Scotland or England, don't. So I think why I'm picking this idea of moral compass of a firm. And a way of looking at your moral compass is, what are you doing to your employees? That's a good place to start, because you'll soon work out whether you are being, fair and ethical, and then move to the next stage and start thinking about our clients, and then starting to think about the decisions. And I think it's very rare. I sit on the board of a financial services a business regulated by AIM, and one of the key things we have to do, because we're in cash management, which, as you can imagine, is fraught with all sorts of interesting risk, is we have a risk. We don't just have a risk register. We have a risk view and a risk appetite around every single type of decision we think our business is going to make. And I just wonder how many law firms actually do have a clear and clearly understood risk appetite within which they have the conversations with their lawyers-to-be, if they're employing trainees, and getting them to really understand, here in firm X, these are the decisions we don't make, and these are the decisions we do make, and these are the things we ask. And when I joined Shell a million years ago and then went to work for Guinness and then Cadbury, maybe really good exemplars of having a core culture and a strong set of values. But boy, did you know very, very early on, what the sort of continuum of judgment was in which you were going to operate. It's the way we do things around here, Tess. You ask in your job the first week, how do I do this? And somebody says, well, the way we do things around here is this. That's your culture. Yeah. And I would really encourage any senior partner, managing partner on this call, any partner, to go around and ask a few people in their firms, how do we do this? Because I suspect they'll get a plethora of answers, and very few will be the answer they'd really want. And that might be a good place to start, because define the answer you want to hear and then go out and have that conversation.
Brilliant. Okay. Well, thank you very much indeed for your contributions on that one. I'm sure we will be revisiting that in our various guises going forward. Matthew, I'm aware you've got to leave us, but just moving on to the next question in relation to the future of regulation. Do you want to just give us your thoughts before you leave in terms of where you think we should be going on legal regulation?
So I'm very happy to. Before I do that, let me say how grateful I am to have been invited today. I've really enjoyed the discussion. I'm taking some things away from this to, feed into the work back at the ranch. And, anyone who's been listening and has been interested, do feel free to get in touch. And, if you want to pursue the avenues further. So in terms of the next question, I'm really just going to leave some very headline thoughts to frame the debate. And in some ways, it's a shame Stephen isn't with us, because I very much had Stephen on my shoulder when I was thinking about this. So there are three things really that I would have said if I was asked to kick off this debate. And the first thing is that while the Legal Services Act definitely leaves a lot to be desired, it's also got some very considerable strengths. And I think the most important of those is its flexibility. And believe me, having worked in several different legislative regimes in my time, the flexibility of the Legal Services Act is very considerable. And I think what that means is there's sort of enormous opportunity, given small and large P political will, to shape and update the regulatory system within the terms of the existing legislation. It's a question of imagination often, and desire, I would say. And I think that's even more important in the light of my second point, which is, when I first joined the LSB, people used to say, well, maybe there'll be reform of the Legal Services Act in the next 2 to 3 years. I think that's hugely, hugely over-optimistic. I think it's over-optimistic to think of the timetable for a more sort of fundamental reform in terms of years. Personally, I think it's likely to be 1 or 2 decades before we see a replacement of the Legal Services Act. Why do I think that? Major flagship reforms like this is slightly tongue-in-cheek, you'll see, but you have to wait for all the civil servants that were involved to retire before they do it again. And that's usually about 30 years. I don't see any sign of reform in this area edging anywhere near the top of the government's list of priorities anytime soon. Some of you will have seen coverage this week that the bill to scrap European legislation, the government had suddenly found another 1,400 rules that needed to be added to the list of consideration for putting on the statute book, or, the legislative system is going to be gummed up for years. So, don't bank on reform to the LSA. And I think that means I'd encourage opinion formers and policymakers, and we've got them on the call today, to be focusing energies on extracting the maximum value from the existing legislation, rather than sort of envisaging the contents of a new act. And the last point I would leave you with is, it's sort of a statement to the obvious, but in deciding where to take the regulatory framework next, I think the primary lens through which one should view the landscape is that of the public interest. And it goes a little bit, links back a bit to the conversation we've just been having. How do we use the regulatory system to secure the best outcomes for the public from the contract between the society, between society and the legal professions? Now, I know that's all very gnomic and has left you lots of space to fill in the answers. So on that note, I do have to go. I'm very sorry about that. And I wish you success for the rest of the event.
Thanks very much. Thanks for joining us.
For stimulating debate.
Thank you. Iain, on that note, can we get your thoughts?
Sorry, was that me?
Yeah. Iain, can we get your? Can we get your?
Beep just as you said my name, so I mean, picking up on what Matthew said, I mean, and as someone who has to sort of navigate himself around the Legal Services Act on a fairly regular basis, it's awful. As there's so much that you would want to change, but equally, Matthew's absolutely right. This ain't going to change anytime soon, so we better just make the best of what we've got. And I think that the two issues that are probably the most prominent now are the scope of the reserved legal activities, which I mean, for those on the call, just very quickly, there are 6 reserved legal activities: litigation, advocacy, reserved instrument activities, which is mainly conveyancing, notarial activities. This is a test now, isn't it? Commissioner for oaths, and I have now forgotten one. It'll come back to me in a second. Anyway, they were passported through from the old regime, such as it was before the Legal Services Act, no doubt avoiding an argument with the legal professions at the time about their scope, and they bear no relationship to the public interest as to what do consumers really need to be protected, and where are the risks to consumers and where do they exist. And they're also horribly unclear as to what they actually mean. Litigation, for example, includes litigations in front of a court, but doesn't include employment tribunal proceedings and most tribunal proceedings. So, and doesn't even include all the steps that one would take in litigation. So I'm at this point, the sort of the great Professor Mayson was obviously the expert in all of this, but he has done quite a lot of analysis around the reserved legal activities, and it seems to me plain and obvious that they need sort of a root and branch review, and there is a mechanism under the Act for the Lord Chancellor to approve their change in scope, and that is what the Legal Services Board has said they're going to embark upon, and that would be a good thing, and I think improve quite a lot. And then the other issue, which is probably a little bit more controversial, if I can put it that way, is the number of approved frontline regulators. I think I'm not going to suggest what the outcome would be, but would just make the observation that, and it's not unique to this jurisdiction, is legal services regulators tend not to be very well resourced or very big compared to the communities which they're regulating. And that equally exists in the bars of Europe. It exists in the state bar associations in the US, because it's a state-based regulatory system. And in a world where we've got quite large corporates providing legal services under the regulatory umbrella, and quite a few large corporates who are providing legal services not under the umbrella, are the regulators big enough to deal with that market? And I don't think they are, and that is going to be an issue that will need to be addressed. How we address it, what the outcome is, I think I'm going to be too reluctant to speculate, but I think that is certainly something that can be dealt with under the Act, but is probably a bit more controversial and difficult to resolve.
Yeah,
those are my thoughts, Brian.
Yeah, no, that's really interesting. I mean, I did see the other day the SRA got certain views on that. So for anybody interested in it, they might want to have a look at the SRA's press releases there. In terms of Chris, from a sort of a professional body side of things, where do you think things are going or should go?
We're going to all sound like hugely in agreement. I wasn't expecting to disagree with Iain at all. And it is a shame Stephen's not here, because he's very capable of talking, should there be reform, what that might, the direction it might go in. But let me start with risk, which is we talked about actually in the ethics piece, and I want to sort of bridge between the two. My general observation is it's how little people in general understand the concept of risk and risk appetite. And if you don't really get that, you will chafe against, as some professions do more than others, regulation in the law, because you don't quite get the fact that it's fundamentally about managing risk. So I start, and CILEX has consistently started, which is, is that for consumers, particularly, it's the public interest argument. We should have as low a risk appetite as we possibly can for the delivery and consumption of legal services, because they are buying something they don't really understand. It's like doctors. Doctor says you need to have this off. Well, who are you to argue? Let's hope they take it off and it's the right one they've taken off. And if it isn't, there's a whole proper way of dealing with the doctor who doesn't do the proper job. And it is quite clear that, particularly for retail consumers, we need a regulatory environment that supports, an orderly and secure existence where access to law is required, be it buying a house, writing a will, dealing with a divorce, dealing with an employment issue, and so on and so forth. And I'm with you, and the problem is we're half in and half out in quite a lot of those areas. And a lot of the complaints that come through, actually less so to us, but certainly if you look at the SRA's sort of long complaint lists or whatever, half of it's around people's misconception or misunderstanding, or I didn't know. So it strikes me that being really clear about the degree of protection consumers need, and recognising, and we as a profession understanding, that needs to be virtually, it can't be no risk, but it needs to be as low risk as possible. We all need to be in that place. I don't think we are as a profession, and that as a range of professions. I think that's a challenge. I do think also that we do need to think about the structural issues that Iain has talked about. At the moment, within the Act, we have a behemoth, which does perhaps have some scale to deal with some of those challenges. And then we have a row of, pretty small, pretty subscale organisations alongside. In the debate around, how you address that, and I'm not going anywhere near the CILEX issue in this conversation. Happy to come back to that next year. But within that, we must be careful not to conflate moving to a bigger regulator that still regulates along a practice line with moving to activity-based regulation, which is not permitted within the 2007 Legal Services Act. The former is possible, and there is a public interest debate to be had around it. The latter is not possible. And I think starting to wave flags that having one debate is going to lead to another, I think is unhelpful as we think our way through this issue of how we expand and define properly what authorised and therefore regulated activities actually are. And if you think about the ethics debate we had, a lot of which, of course, about corporate law, we then have to start asking ourselves questions, not just about small businesses, who I think are as vulnerable as retail consumers to the problems with a poor legal service, but also larger corporates, and how we start to regulate those sorts of decisions, particularly when, in some aspects of corporate law, you don't necessarily need to be a lawyer to be delivering the service, or legally qualified to be delivering the service, or qualified and regulated in England and Wales to be delivering the service. And there are big questions there that I think can be and should be addressed within the current Act. the importance, I think, I want to go then further. If we ever got a chance to address the fundamentals of what is really, I guess, the sort of Clementi compromise that became the Act, if we were ever able to do that, we need to think about activity-based regulation, because we now have a diverse legal profession where in some areas there is a choice of more than two types of lawyers who could deliver a service. And it is very important from a public interest perspective that there is clarity to the standard in which those lawyers are working are aligned. And that it is not clear today, and it's not clear for the public. The second area, I think, where there's a strong reason to consider activity-based regulation is because is the rise of technology. The more you disintermediate between the giver of the legal service and the consumer of the legal service with some form of digital platform, the more you have to ask the question, who's regulating the person who writes the algorithm? Because it's the algorithm that will deliver the service, not the lawyer. And at that moment, you have to start thinking that it might be worth moving, in some areas certainly, to activity rather than individual. Because if you don't, there'll be this lacuna of unregulated activity and risk, which ups the risk to retail consumers. And if you think about the basis of regulation being a low risk environment for retail consumers, we are at risk, I think, by not addressing that issue, that we're going to inadvertently, through an obsession about title-based regulation, we're going to inadvertently put the market at risk. And that isn't good for legal services as a sector, and it's not good for legal services in England and Wales, which is a global centre of legal services for a very large number of organisations.
Thank you, Chris. I'm very aware of time. I saw that we hadn't got any questions on the system, which is why I obviously allowed things to roll on. But really interesting discussions. Really disappointed that Stephen wasn't able to join us for the full session. But as many of you will know, Stephen is always out and about, putting his thoughts around, and certainly we engage with Stephen a lot. So, look out for further events where, we will be inviting him. But on that note, thank you very much indeed, Stephen, for the contribution that you did make. Thank you, Chris. Really interesting to hear your thoughts. The same with yourself, Iain. And although Matthew's obviously gone, very grateful for Matthew's input as well. And hopefully we can do something similar in the future. Certainly, there's plenty to keep on discussing in relation to all of this stuff. So on that note, thank you for attending. Hopefully you found the session really useful. And if you would like any questions asking offline, then please do let us know. If there's anything you want us to put to Iain, Stephen, Matthew and Chris, then again, let us know. If you can't contact them direct, and we'll send them the questions on. So on that note, thanks very much indeed. And as I say at the end of all of my webinars and seminars, please do stay safe. Thanks very much. Bye-bye.
Thank you.
Thank you.